We're getting breaking news that the Supreme Court has commuted Devinder Pal Singh Bhullar's death sentence to life now. That's the latest that's coming in this case. Remember, this was a protracted case and a lot of arguments were given against and pro the death sentence. However, now we understand that the Supreme Court has finally taken a call on this matter. It has commuted Bhullar's death sentence to life. Remember, there are details coming in at the moment. In fact, our correspondent Jaskirat is joining us with more from the Supreme Court. Jaskirat, what's the reason behind commuting the death sentence to life?
Well, primarily two principles on the basis of which the Supreme Court has decided to commute Devinder Pal Singh Bhullar's death sentence to life. The first being that it is now proven that he is in fact suffering from acute mental illness. And the second and the larger principle being the guidelines that were laid down on January 21st by the Supreme Court itself in what we call the Shatrughan Chauhan judgment, when various reasons were given as to how a death sentence can be commuted to life sentence, especially if there is a delay in deciding on a mercy petition. Now that is also taken into consideration because last week itself, the Attorney General of India had conceded that there was in fact a delay, and that's not just restricted to one government, but overall there was a delay in deciding on the mercy petition. The Supreme Court has already dismissed the government's challenge to that judgment. So as per the judicial norms and as per whatever is a standing ruling of the Supreme Court, the government itself has put a stamp of approval suggesting that they do not plan to go ahead with the execution or the death sentence. In any case, Devinder Pal Singh Bhullar right now is under psychiatric care and not inside the prison. So taking all those things into consideration, that today the Supreme Court has finally passed its ruling and judgment that Devinder Pal Singh Bhullar will not hang, and his death sentence has been commuted to that of life in prison. Okay.
Jaskirat, also you mentioned the January 21st judgment that talked about a delay in deciding mercy petitions. I'll come back to you, Jaskirat. We're getting to hear KTS Tulsi at the moment, senior advocate. Let's listen in first to him.
मौत की सजा को कम करके उम्र कैद में तब्दील कर दिया है और दो ग्राउंड्स हैं. एक तो 8 साल की इनऑर्डिनेट डिले जिसका कोई भी एक्सप्लेनेशन नहीं है, ये बिल्कुल अवमाननीय है और इसीलिए इस ग्राउंड के ऊपर मौत की सज़ा को गैर कानूनी हो जाती है. शत्रुघ्न सिन्हा में जैसा उसको फॉलो करते हुए उन्होंने इस मौत की सज़ा को कम करके उम्र कैद की सज़ा में तब्दील किया है. सुप्रीम कोर्ट ने इस बात को भी ध्यान में रखा है जो 5 फरवरी 2014 की रिपोर्ट देविंदर पाल सिंह भुल्लर की सेहत के ऊपर, मानसिक स्थिति के ऊपर आई, उससे ये सिद्ध होता है कि अभी भी भुल्लर साहब एक मानसिक बीमारी का शिकार हैं और इसलिए उनको मौत की सज़ा नहीं इम्प्लीमेंट की जा सकती. तो दोनों वजह के मुताबिक उसकी सजा को कम करके उम्र कैद में तब्दील कर दिया गया.
एक लास्ट सवाल हो रहा है कि क्या जो उम्र कैद है इसमें 14 साल या 20 साल के बाद उन्हें कुछ राहत मिल सकती है, ऐसा भी कोर्ट जो कोर्ट 30
नहीं, इसमें तो सिर्फ मौत की सजा को चुनौती दी गई थी. अब कानून के मुताबिक जब भी उनकी उम्र कैद पूरी हो जाती है या हो गई है, उनको रिहा करने का अधिकार होगा. The Supreme Court today, in the case of Devinder Pal Singh Bhullar, has eventually reduced his death sentence and commuted his death sentence to that of life imprisonment. This has been done principally on two grounds. One, that the case is squarely covered on both counts by the judgment of Shatrughan Chauhan, a judgment of 3-judge bench, which was as recent as January 2014. In the case of Bhullar, the court has noted that there is a delay of 8 years, which is completely unexplained and is therefore inordinate and amounts to cruelty. The second ground is that the mental condition of Bhullar has been examined in the context of the report of several medical boards that have been constituted in the last 4 years, and the last report of the last medical board, which was received by the court on 5th February 2014, according to that also, the unanimous report is that Bhullar continues to suffer from mental illness of some kind, And therefore, on both grounds, the Supreme Court has commuted the death sentence. All that I want to say is that these death sentence matters should be dealt with a little more expeditiously. And also today it raises an important question as to whether, when there is a difference of opinion between judges of the Supreme Court, there can ever be death sentence. According to Bachan Singh, the death sentence can be awarded only in the rarest or rare cases. Rarest or rare would mean when there is not even 0.1% doubt about the guilt of the person. And in this case, out of 3 judges, if one acquits the accused on the ground that there is no legally acceptable evidence and that his confession has been extorted illegally, still if the 2 judges wanted to convict, they could convict by majority. But grant of death sentence in a matter where there is 33% doubt with regard to the guilt of the accused is something which must be seriously considered by the Supreme Court in all future judgments. Because this court has held that even in cases where the learned sessions judge acquits the accused and the High Court convicts and awards death sentence, that's not proper. If one of the courts thought that the accused is not guilty, is innocent, then award of death sentence by majority judgment is not permitted anywhere in the civilized world. And we must reconsider the process by which the death sentence is awarded only by majority, and that also a wafer-thin majority. The other question that has been referred to the Supreme Court by the Law Commission is that death sentence matters must be considered by a constitution bench of at least 5 judges. We need to ponder over these issues, and I hope that the learned Chief Justice, who has established himself as a great humanist and has advanced human rights jurisprudence in these cases pertaining to death sentence, will have the time to also examine the 2 outstanding issues related to the death sentence on the same humanitarian ground. Thank you.
That was Senior Advocate KTS Tulsi outlining the reasons why the Supreme Court considered the case fit for commuting the death sentence of Devinder Pal Singh Bhullar to life sentence. Mr. Anthony, a human rights activist, is now joining us on the phone line. Mr. Anthony, certainly human rights activists would today welcome this move of the Supreme Court.
Absolutely, I welcome this move, and I must congratulate to Honorable Supreme Court commuting the Devinder Pal Singh Bhullar death penalty to the life sentence, because of it's a delay for like anything. And in my simple language, because I'm an advocate also in Supreme Court, it is my simple sentence that delay in the justice means justice denied. This is my simple.
Mr. Anthony, inordinate delay was one of the reasons for commuting the death sentence to life imprisonment. Also the fact that a medical board report said that he was not mentally fit. But do you think that it is high time that India takes a decision on death penalty per se?
Yeah, it is a very important matter, and everybody knows about that. Because of certain political reasons, there are a lot of they take a big time to decide on the execution of the accused. But it should not happen. It should be decided as much as at the earliest. That's the thing.
Mr. Anthony, many thanks for speaking with Headlines today and giving us the perspective of human rights activists who certainly are welcoming this move of the Supreme Court to commute the death sentence to life for Devinder Pal Singh Bhullar. Let me go back to Jaskirat Singh Baba, our correspondent, joining us with more details from the Supreme Court. Jaskirat, was Devinder Pal Singh Bhullar's case also strengthened by the fact that the centre had also told the court last week that it had no problem with Devinder Pal Singh Bhullar being spared the death penalty?
Well, absolutely. I mean, what was happening today was pretty much on expected lines, specifically after the Attorney General informed the Supreme Court about what you just informed the viewers about a while back. However, why did the centre or the Attorney General inform the Supreme Court about that? It's very important to understand that. It's because the centre had actually challenged the Shatrughan Chauhan judgment and had said that it's not your prerogative but the President's prerogative, and when the decision is pending with the President, the Supreme Court should not be interfering. That review petition was dismissed. After the review petition was dismissed, and in any case, curative petition, which is the next line of action, have a very slim and a decimal point or fractional chances of success. The government finally decided that since the review petition was dismissed, they finally would fall in line with what the Supreme Court said in the Shatrughan Chauhan judgment and conceded to the guidelines laid down in that judgment, and pretty much said that they will not go ahead with the execution or with the death sentence execution because of those guidelines. However, very important to understand that those guidelines in the Shatrughan Chauhan judgment also pulled up the government and the bureaucracy as a whole for not putting a proper system in place and having an endemic system of delay in deciding on mercy petitions, irrespective of who is in power.
Jaskirat, many thanks for joining us with all those details from the Supreme Court.